The Fourth Amendment: origins, development, and modern application. They who can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. Benjamin Franklin, 1755. The house of everyone is to him as his castle and fortress. Sir Edward Coke, 1604. The Fourth Amendment to the United States Constitution protects citizens from unreasonable government searches and seizures. This fundamental protection emerged from colonial struggles against British tyranny, and courts continued to struggle with balancing individual privacy rights with law enforcement. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The amendment's roots trace back to Sir Edward Coke's Castle Doctrine in the 1604 Semaines case, establishing that every person's home is their castle. The case also created the knock and announce rule that remains part of American law today. However, the king could authorize general warrants, which abrogated Coke's legal principle. General warrants were the opposite of Fourth Amendment principles. These broad authorizations did not specify areas to search or items sought, lasted for the king's lifetime plus 6 months, gave holders of the warrants nearly unlimited search power. Modern NSA data collection and secret surveillance courts echo these unchecked general warrants. A writ of assistance was a special type of general warrant used to search for goods smuggled to avoid customs taxes. These writs required the assistance of local sheriffs and loyal subjects in their execution. Writs of assistance were not limited to specific locations or items. They allowed unlimited searches anywhere, anytime. In 1760, colonial British officials cracked down on smuggling using these writs. Boston merchants, the main targets, believed such writs violated English common law dating back to Sir Edward Coke's Castle Doctrine of 1604. Colonial lawyer James Otis represented the Boston merchants against the writs of assistance. On February 24, 1761, Otis argued for 5 hours that these writs violated English common law, citing the Magna Carta, Coke's Castle Doctrine, and natural law principles. He contended that writs of assistance, as general warrants, were illegal under English law. Though Otis lost the case, his arguments deeply influenced young John Adams, who was present in the courtroom. Adams later helped edit the Declaration of Independence, incorporating Otis's natural law arguments. This case provided the intellectual foundation for the American Revolution. While Americans faced expanding general warrants, in England, courts were declaring such warrants illegal when used to search private property in England. Between 1763–1769, multiple cases established that general warrants violated English common law. In 1767, while English courts were protecting English subjects from general warrants, Parliament passed the Townshend Acts, authorizing colonial courts to issue writs of assistance. This unequal treatment, protecting English subjects in England, while depriving American colonists of rights accorded Englishmen, became a major factor leading to revolution. The Fourth Amendment's warrant requirements reflect the natural law principles announced in the Declaration of Independence. Government does not grant rights, it exists to protect rights. People are born with inherent rights that exist without government. These include right to privacy. People naturally deserve personal space free from interference. Right to property. Individuals have natural ownership over their belongings and homes. Right to security. People should be safe from arbitrary government power. Individual sovereignty. Each person has inherent dignity and self-governance. James Otis argued that writs of assistance violated these natural law principles by treating colonists as subjects without natural rights. The founders designed the Fourth Amendment to protect natural rights by requiring government to justify searches with probable cause and obtain permission from neutral judges. This natural law foundation explains why the amendment protects persons, houses, papers, and effects. These represent the spheres of individual autonomy that government cannot invade without proper justification. Supreme Court precedent holds that the Fourth Amendment prefers searches conducted with warrants based upon probable cause. The basic rule is that searches conducted without prior approval by judge or magistrate are per se unreasonable. Probable cause requires that facts and circumstances would lead a reasonable person to believe a crime has been committed and evidence will be found in the place to be searched, or the person to be arrested committed the crime. This standard requires specific facts, not hunches, and is more than suspicion, but less than beyond reasonable doubt. Courts use a totality of circumstances approach, considering all available information including officer experience and training in making decisions to issue warrants. Exceptions to the Fourth Amendment warrant requirement allow searches and seizures upon probable cause exist. Exceptions include search incident to arrest. Exception. Police may search arrestees and their immediate area for officer safety and to prevent evidence destruction. Automobile exception. Vehicle searches with probable cause don't require warrants due to mobility and reduced privacy expectations. Exigent circumstances exception. Emergency situations like hot pursuit or imminent evidence destruction may justify warrantless searches. Plain view. Exception. Evidence in plain view may be seized if the officer is lawfully present and the evidence's criminal nature is immediately apparent. Consent exception. Voluntary consent eliminates warrant requirements, but consent must be freely given. The knock and announce rule dates to Sir Edward Coke in 1604, requiring police with warrants to knock and announce their identity before entering a home. Exceptions exist when announcing would be dangerous, allow evidence destruction, or permit escape. Evidence obtained without a warrant or exception to the Fourth Amendment generally cannot be used in court, based on the principle that government and its agents must comply with constitutional procedures. This is the exclusionary rule. The digital age presents new Fourth Amendment challenges. The Supreme Court recognizes that government generally needs warrants for searches infringing reasonable privacy expectations. Current issues include keyword search warrants of computers, cell phone searches requiring heightened protection due to vast personal information, surveillance technology, GPS tracking, and facial recognition. When the Constitution was written in 1787, it lacked individual rights protections. The founders, having learned from battles against British general warrants, wanted to prevent the American government from similar abuses. On December 15, 1791, Virginia became the 11th state to ratify the Bill of Rights, making the Fourth Amendment part of the Constitution. The Fourth Amendment protects Americans from unreasonable government searches by requiring warrants based on probable cause. From James Otis's 1761 courtroom arguments to modern digital privacy, the Fourth Amendment continues balancing individual freedom with law enforcement. In a world brimming with technology, the core principles of the Fourth Amendment remain significant. Ultimately, it reminds us, to intrude into your castle, the government must have a valid reason. Do you think the balance between security and privacy is being achieved today? Share your thoughts in the comments. Subscribe to Constitutional Soundbites. Like and share this video to combat constitutional illiteracy.